Okay, so we're here today again doing another session. And today I've got Eugene Jakubov with me from Canadian Business and Enterprise Services. They work with compliance and corporate and incorporation services in Canada. So, Eugene, you're located in Canada. How are you?
Hi, Lynn. Good, thank you. Yes, in Toronto, here in Ontario.
Yeah, super, super. Lovely to have you here.
Yes, nice to be here too. Thank you for inviting me.
Absolutely. It's great to have you here. And we're here today to talk about shares versus assets when it comes to selling your business from a legal standpoint, because Eugene here is the managing director and a legal counselor. So he works with clients who go through this on a daily basis.
Yes, that is correct.
Yes. Super. Okay, so let's jump into it. When it comes to shares versus assets, and you're a business owner looking to sell, what does that mean? What does these two different transaction structures mean for a business owner?
So essentially, Lynn, when a person comes to a position and decision to sell their business, it's important to understand the difference between these two transactions and how they will affect the course of transaction itself, as well as whatever happens after the transaction is closed. And maybe a first step that the business owner should take is to remember why they initially incorporated. Incorporation was created to support two major areas of concern for business owners. One is the mitigation of legal liabilities that arise from business operations of business. So if the claim comes up, it stays within the corporation and does not flow into the personal assets of that person. And the other one is taxation. Essentially, the same kind of considerations we would consider when we come to sell the business. And that's why I say in most of the situations, the seller's preference would be to sell the shares. The difference of these two transactions is when you think about the corporation as an envelope and the business as a content of that envelope. When we sell assets, we sell the content, but we still keep the envelope. When we sell shares, we sell the whole thing, including the envelope and the assets of the business. And the main difference in this transaction is specifically the question who stays with the envelope. Because you remember, envelope brings the liabilities and keeps the liabilities. And as business owners, in many cases, we would be considered as directors, shareholders, and officers of the corporation. Most of the jurisdictions in Canada, in the US, would imply legal liabilities on directors attached to the operations of the corporation. So legal compliance, tax payments, certain future legal claims, administrative actions will always be attached to directors as well as to the corporation. And if we really decide to sell our business, step out of it, disconnect from it as a what I call clean cut separation, what we want to do is to transfer our shares to that new business owner, the buyer, and say farewell to the business, wish them good luck, and never get attached to it or never get anything connected between us and the business. With the sale of assets on the other side, that is specifically the opposite thing that happens. So we sell the business, essentially it's assets, physical, tangible or intangible assets. We can sell a name, intellectual property, equipment, list of clients sometimes could be a very valuable assets of a business. But the envelope with all its contents, legal liabilities, stay with us. So this is the major difference between two approaches to these two forms of the same transaction.
Yeah, absolutely. And that is, I mean, that's a bit of a push and pull, right? The business owner would like to go for that share to separate
Correct.
from liabilities, versus the buyer who would typically prefer an asset purchase where the liabilities or majority of them would then stay with the seller,
Correct.
which brings us into the next topic. So what are the different liabilities under these two different structures?
So when we operate a business, we always create certain scope of liabilities. Sometimes come to fruition and become legal claims or administrative actions, mostly and hopefully none of them actually happen and we just live happily thereafter. But we're talking about multiple areas of concern, starting from employment law. So when you have employees, certain issues could get attached to the corporation and through the corporation to directors, depending on the jurisdiction where you're located. So unpaid wages, unpaid vacation time, overtime, injuries that happen to employees prior or after the transaction. Then we have the taxation. And just like in Canada, US is an extremely complicated jurisdiction from the tax perspective. There are multiple reporting responsibilities. And when we fail to report, the liability stays between the corporation and the directors, officers of the corporation. Eventually, we speak about the actual commercial liabilities. So when we provide services or sell products, there's a product liability. We provide warranties, guarantees. We supply products that might cause damage. You see a lot of recalls in automotive industry or electronic industry that might happen a year, 2 years after you've sold the product. And all these will eventually roll back into the corporation. So these are the major 3 areas of concern: employment, administrative taxation, and product liability or commercial kind of responsibilities that we bear as business owners towards third parties.
Yeah, that's a really good point. That's very important to think of when you're a business owner selling your business,
Yes,
and also making that risk assessment of what it might look like in the future when you're making that choice, whether you're going for
absolutely.
shares or assets. Yeah. And what would you say are the implications that you see that are common based on these two different structures?
So when we as a seller approach the transaction, we have to think about all those strings that connect us to the corporation, and essentially go step by step, disconnecting those strings to the maximum available extent. So we start from the sale. If we proceed with the sale of shares, we sell the shares, but the transaction itself should consider all those liabilities and cover them specifically in contractual provisions that the buyer will either undertake those liabilities or indemnify us from future claims in the case that those liabilities still flow through the corporation and somehow get attached to us. So we would first of all define the nature of transaction. And the nature is, as we say, we proceed with the sale of shares. I'll speak about assets in a moment. Then we'll define the administrative disconnect from the corporation, which means we want to get ourselves removed from all corporate registries, such as directors, officers, managers of the corporation, from both internal and external registries. So every corporation has its internal minutes book or bylaws, registries, resolutions. There we should provide our resignation from a position. Then we have to make sure that the same is applied with the registrar or jurisdiction where the corporation is registered. So the government authority knows and is being notified that we have disconnected from that corporation. Second step, we have to define what happens with the existing operations, specifically such things as employment, ongoing contracts, contractors that work for a corporation. You have to negotiate it in advance with the buyer, because in most of the cases, those who want to buy a business will, although take the employees with them, many situations consider making restructuring or combining your business with the existing business, which will reduce the need in labor. And that can result in termination of employments. Multiple jurisdictions will put certain liabilities on a corporation as an employer. As a result of those terminations, you want to make sure that you are not attached to all those conflicts that might go on for years after the transaction takes place. Contracts, you want to make sure that every ongoing contract, such as supply, service that you already started, but now someone else should continue, are being properly transferred. And you have to keep in mind that those clients that signed the agreement with you, they signed sometimes agreements with you because that's specifically you. Now, you don't want to come to them as a surprise with someone else and that someone else start providing or continuing providing these services. You want to advise your clients in advance. You want to let them an opportunity to consider whether they want to continue or cancel the agreement. Same thing with the all the suppliers that supply your business, starting from such major things as utilities. In many cases, I find my clients suddenly come to me a year after a transaction being closed, saying, oh, by the way, I got a phone call from a phone company or internet supplier or whatever else, asking me to pay bills that stayed unpaid for the last 6 months. And the main point is to literally go through your accounting system, see every bill recurring specifically that you're paying as a corporation, and make sure that your name is no longer there. Finally, as I said, the indemnity. Indemnity is a special legal terminology that provides you with a solution in a case of legal claim. So sometimes situations happen and claims occur. Me as a lawyer of the third party that wants to sue a corporation, I will try to catch as many people, as many companies in my net as possible to make sure that if I'm successful with my claim, I have enough assets to get paid from. So I might file the lawsuit against you as a former owner of the business because the service or product were provided while the business was still operating. At that case, what you want to make sure that is properly defined in the agreement is that the corporation and its new buyer will indemnify or protect you from those future claims. And if those claims become successful, they will pay the costs and they will pay the orders and the actual lawsuits that they have lost, and not you and not your personal assets will be at stake. So these are like the major areas of concern that we should cover from both the corporate direction. So you should think about corporation that releases you from those liabilities, but also from your personal direction where you ask the corporation to get released, where you notify the corporation that you resign, and that you disconnect all these strings that essentially and initially attach you to the corporation.
Yeah, really good point. That's very important because that could affect you personally as a
Yeah,
previous business owner if everything isn't covered completely there. Yeah.
correct. Now,
Um,
if I may, 1 minute, and that's what I said.
Absolutely.
Uh, a little bit different approach we'll have in the situation of sales of assets, where corporation stays with us, and we have to understand what exactly that we are selling. Do we sell the whole business just except for the corporate structure? And then most of those questions will remain the same. You still have to transfer employees, your assets, your contracts, your suppliers, or you sell part of it and you stay with the remaining part, and then it will, of course, complicate the transaction even further.
Yeah, yeah. Which is why the seller usually prefers the share sale.
Exactly.
Um, and when it comes to the physical exit, when it comes to the registries, transferring accounts, and actually exiting the business, how does those two structures, how does it differ?
So, from the actual physical perspective, those transactions would look very similar because the essence of the transactions, both of them at the end of the day, is to buy your business. Buyer is not interested too much, except for very, very specific situations in the legal envelope of corporation. The buyer could be interested in it in the case of licensing. So let's say there's a specific license that is attached to a corporation. A good example is the transportation industry. When you have trucking company, you have multiple licenses that are specifically attached to the corporation, and I as a buyer might want to buy the corporations specifically for that purpose. But other than that, physically, when I buy the whole business as a scope of assets or as a shares, the physical transaction would be almost the same with one difference. In the sale of shares, you will actually sign the shares transfer documents. So if you obtain the share certificate, that nicely printed piece of paper with your name and the number of shares, at the back side of it, you will have the transfer where you will sign that you transfer the shares to someone else. If you didn't get those shares, you will be just signing the corporate resolutions approving that transition, and that's it. Except for that, you will be physically transferring the whole business, everything that you agreed for, to the buyer. And of course, don't forget, go to bank, go to your utilities providers, and make sure that your name is being removed from all those accounts physically, not just in the agreement itself, because buyers will get busy very fast in transitioning and adopting your business, they might most probably forget about it or just decide not to do it for whatever reasons. You don't want to find it out when it's too late already.
Yeah, absolutely. This is this is actually us coming to the end here. Thank you so much. It's been very insightful.
Thank you,
Um,
Lynn.
Thank you. And before we go, we will have the contacts and notes, but where do people best get in touch with you if they need help with this?
So as we got in touch, you know that I'm trying to facilitate a YouTube channel with recurring success. My YouTube channel is called Business in Canada Do It Right. But I think that many of the topics that I cover there could be very relevant for the US companies as well. I work with lots of US clients, and I see that in most of the situations, the logic behind topics would be almost the same. It's just the technicalities would change. You can always find me as a member of your community here, as well as LinkedIn. My contact information in Canada is email eugene.j@cbes.ca, and the phone number 647-569-2377. Any corporate questions, business development, I'm here to answer them.
Super. Thank you so much.
Thank you, Lynn. Thank you for having me.
Thank you.